Welcome to MF Garza Law Firm, helping injured victims, one Texan at a time.
Hello and welcome back to MF Garza Law Firm, helping injured victims, one Texan at a time with Miguel Garza. Miguel is the founder of the MF Garza Law Firm, where he fights for Texans injured in accidents ranging from car and trucking crashes to catastrophic injuries. My name is Kevin Rosenquist, and in this episode, we're talking about contingency fee contracts. Miguel will explain what they are, how they work, and why they're important in a personal injury case. Miguel, welcome back.
Hey, good to see you again.
All right, let's start out with the obvious question. What on earth is a contingency fee in a personal injury case?
Well, contingency fee contract basically means if I don't get you a settlement in a personal injury case, then you don't owe me anything. It's contingent upon me getting you a settlement and getting you compensated before you actually pay me anything. This isn't an hourly fee type of contract where you have to pay me a $5,000 or a $10,000 retainer up front. That's usually what happens in family law or criminal law cases, things like that. Basically, I'm giving you the benefit of the doubt that our case is going to be successful, and I'm going to assume all the risk, which is why you don't have to pay me anything up front. So usually, as I tell clients, is that if I don't get you a settlement, you don't owe me anything, and really it's something that I take the risk on. And if I don't get you something that you approve of, then you don't owe me anything. But obviously, once we do get some sort of settlement or some type of offer, then my fee comes off of that gross settlement amount.
Okay. All right. Well, that's nice for people if they don't, if they're not exactly sure of how much it's going to cost them, it won't cost them anything unless they win.
Yeah, exactly. And, the one thing I always tell people is that at the end of the day, I'm going to show you a statement. It's basically like a banking statement. You're going to see where every penny is going in the case, fees, expenses, whatever the case may be, and you'll see what your net settlement is. And if you don't approve that amount, then I'm not going to accept any settlement on your behalf. And one of the best things about that is for a personal injury case is that you don't have to pay any taxes on the settlement that you get. It's tax-free under the tax code. But I do recommend you talk to a tax lawyer just in case, but you don't have to pay any taxes on that.
I didn't know that. That's interesting.
Yeah.
Okay.
So, yeah, one thing the government got right.
Yeah. Hey, look at that. We found one. What's the usual percentage charged in contingency fee agreements? And does that percentage change depending on the stage of the case?
Yes. Typically in the claims process, or we say pre-litigation process, with nothing involving a lawsuit, it's typically a third, which is 33.3%. And that usually entails you getting a medical care and submitting a demand letter that basically requests or demands a certain amount of money on your behalf, and then we try to settle the case in the claims process. So that's 1/3 of the gross settlement for the attorney fees. If we have to file a lawsuit, then the fees generally go up to 40%. And the reason why they go up is because it's going to require a lot more work on behalf of my staff, myself, and possibly have to obtaining additional counsel depending on the complexity of the case. So I have to draft motions, I got to go to hearings, I got to go to depositions, and it's just a lot more work intensive on my staff and I. So that's why the fee goes up. And then also, if we have to appeal something, then usually there's appeal costs included in that. Doesn't usually happen unless it's more of a unique or complex case, but it's typically 1/3 and 40% if we have to file a lawsuit. Now, some other firms that you may see on all these billboards or whatnot claiming to have all this crazy, unique experience may charge quite a bit more because they throw all this money into advertising and they have many, many employees. So, but the standard fee is typically 1/3 and for a claims process and 40% if a lawsuit needs to be filed.
Okay. Interesting. Yeah. And when you have to do, when you have to hire outside help, like investigators, expert witnesses, that kind of stuff, are there any upfront costs in a contingency fee case, or is that you don't charge for those unless you win?
That's correct. Yeah. So one of the other things that I assume the risk on is advancing all legal expenses. So depending on the case, like I said, if we have to hire a particular, physician, like a life care planner, to say that, you're going to require all this medical treatment through the remainder of your life for 20 or 30 years, whatever the case may be, it's going to cost this much, and you have to have an expert. justify that in terms of evidence and prove that up. Another one could be like a highway traffic safety engineer or an accident reconstructionist engineer that will come in and recreate an accident that, such as like in a big 18-wheeler wreck, that take digital scans, measurements, and a bunch of other data that they get from the vehicle, like from the black box data, and they recreate the accident and really helps us find out all the little nuances and facts that maybe we couldn't find out through testimony or photos or witness statements, things like that. So we take 10 attorneys myself, usually advance all that. We pay it up front. You all don't have to pay anything. And that's one great thing to having an attorney like myself, because again, we take care of those costs and you don't have to pay anything up front.
Got to have confidence in what you do to offer that one, Miguel.
Absolutely. That's why we typically vet the case, on a case-by-case basis. We just don't sign up any case. So got to make sure that it's a viable case, and most importantly, make sure that the client has a good case and they're going to do what is necessary in order to get the type of compensation that they're entitled to.
You mentioned before about the itemized bill, so to speak, or the receipt of all the things that went out. Do you sit down and explain that breakdown so that clients understand completely where all the money goes?
Absolutely. And that's one of the things that I promise that I'm going to give every client at the end of their case, because some attorneys have their clients sign a contract, what's called a power of attorney, where they can sign on their client's behalf. I don't do that. Usually when I come through and do this, I want the client to be fully aware. I want them to approve the settlement amount and have to take my recommendation and advise, I think this is a good settlement, you should take it, or I don't like it, we should pursue other avenues and potentially go to trial and get more aggressive on the case. And typically that helps motivate a settlement when the defendant's feet are being held to the fire, so to speak, and when trial is like the next Monday and it's a Friday. I've had several cases settle like that. So that's definitely a big picture that we usually take into consideration, that I want the client to know everything, because if we go to trial and potentially we lose, then I'm not going to be able to pay off all their medical bills, or I'm going to lose a bunch of money for my expenses and things like that, and I eat that cost. Or I want to make sure that they know all the risks associated with it. Like, can we get a settlement offer? This is guaranteed money, or are we going to go roll the dice at trial and let's see what a jury does? So have to explain it all just to make sure to cover all my bases and make sure the clients are properly informed.
Yeah, that's got to be a tricky situation for you sometimes too, because ultimately you're working for the client, so it's up to them at the end of the day whether they want to go to trial or whether they want to settle or accept something or all of that. But you obviously have a good sense of how things are going to go. Do you find that people more averse to trial? Do they want that trial, or is it just kind of 50-50?
Great question. So typically it depends on the facts, case by case basis. Do we have a very, very strong case where it's clear the other party is at fault, or maybe the company was grossly negligent in training their driver? Whatever the case may be, if we have great facts, then typically the other party is going to be more inclined to settle. Like, for example, if the truck driver was driving under the influence of something, that's a slam dunk case generally on the liability side. So that's generally what we like to see. But if it's like a he said, she said kind of thing, like, you ran, like, no, I had a green light, or like, no, I had the green light, or I had the green arrow, whatever the case may be, then there's obviously risk associated with that. And if we go and tell our story and we don't have the best facts, or we have a witness to help justify our client's position, then we're essentially rolling the dice and may have to accept a lower offer than we want. Because, like I said, if we're getting an offer that's guaranteed money, but if we go to trial, we're rolling the dice and could have a successful outcome, could not. Usually trial lawyers like myself like to go to trial. We like to be in court. That's fun to us. And it's obviously can be stressful, but it's very rewarding. And some clients like that stuff too. It just depends if that's the type of person they are, if they're comfortable being in that setting, because they got to tell a jury of 6 or 12 people their story and why they feel they're entitled to this type of compensation that we're asking for. And, may have to bring family members or friends or coworkers in to help testify and support their position. So, there's a lot of a lot of bits and pieces that, are in the puzzle to help make the grand scheme of things to be a successful case at trial. So just
Hmm.
really depends on a case by case basis.
Yeah. Yeah, that makes sense. What are there specific protections in place under Texas law that ensure that these contingency fee contracts are truly fair and equitable for the client?
Absolutely, yeah. So one thing that the Texas State Bar does is enforce ethics rules on attorneys like myself. There's an ethics code that attorneys have to abide by to ensure that we are ethically and zealously representing our clients to the best of our ability and having their best interest at hand. We're not just obligated to go and take a case and be like, I'm just going to take my fee. I don't care if you're happy or not with this settlement, and obviously that depends on the trust issues or the trust that you may have with your attorney and his staff. You want to be able to be comfortable with somebody and really ensure that this is somebody that I want representing with me. I want them to represent my best interest. And you really just got to properly vet the attorney for that. And that's one thing the Ethics Commission and the ethics rules help apply to make it safer for clients. But also, generally just contract laws apply. If you feel that an attorney breached the contract and didn't do what they're obligated to do per the contract, then you have a claim against them, whether or not it's for breach of contract or something like a malpractice lawsuit, doing something that's unethical, where the lawyer can be held responsible for the damages that they possibly could have gotten for the client, but they didn't want to maybe go to trial and they settled for something less in opposition to what the client wanted. And then another thing I always tell clients in the contract, and it's listed in my contract, if you ever have any issues with me and the way that I practice law, here's the phone number to the state bar, and it'll provide you with the information you need to file a grievance against me. And the state bar will take action and investigate me personally to find out if I'm conducting myself in a professional and ethical manner.
Can you share an example where the contingency fee arrangement made it possible for a client to pursue justice they otherwise wouldn't have been able to afford? I'm sure you have many, because it seems like a lot of people in this situation probably don't have the kind of money that a lawyer would cost up front.
Absolutely. And if the best thing about it is, again, you don't have to pay for anything up front, and the other thing is that I always tell clients, like, look, I assume the risk. You don't have to pay me anything up front, and I'm here to help you and try to get you the best result possible. But the caveat is that you need to listen to my instructions. We're creating a relationship. We're together. We're a team. We have to trust each other. And if you don't do what I say, or you don't take my advice in a particular situation, you could potentially negatively affect the case. And that's why you got to trust and vet your attorneys and make sure that you find them to be credible and that they have your best interest at hand. Otherwise, if you don't listen to what I have to recommend, then that's going to make me think that you don't trust me, and you may not have the best impression of my law firm and that maybe we should go our separate ways. But if you don't have the money to pay an attorney, then typically having somebody like myself is a great benefit to not only them, but their family. And I can help you get justice. But it goes both ways. You have to help me help you. And if we don't do that, then you may have to end up paying for medical bills or, legal fees if you didn't listen to my recommendations. Because I also tell clients that if you fire me without just cause, or just some nonsensical reason, some people just may not have a good reason to do that, then I have the right to assert an attorney's lien on their case, so I can be compensated for my time that I put into the case.
Right.
So it can go both ways, and but it definitely is for the greater good of the client if they can't afford an attorney, because I can certainly help them with that.
You brought up a really good point. If they're not listening to the advice you give them, they obviously don't trust you in trusting your knowledge of how all of this works. And really, then maybe you're not a good fit. A fit is really important, especially it seems in this situation, because you don't get paid unless they get paid, obviously. So you're going to work hard for them to get paid, because everyone wants to get paid. Everyone wants justice to be served too. But it's interesting. I didn't realize that you could go after the lawyer. I forget what you call them. The certain fees that you're lien.
Oh yeah, it's an attorney's lien.
Yeah, interesting. But it makes sense. It makes sense.
Yeah. And there's like hospital liens, contractor liens, mechanic liens, this for work that they've done that they file with the county that they have to be paid for if they try to pursue anything else regarding that particular claim. So, very, and like I said, I've never had to do that in my career. And I hope I never have to, but this is just something that I fully disclose to the clients and make sure that they understand that, we're a team and we got to work together.
Yeah, absolutely.
Yeah.
Do you find that there's a fair amount of misconceptions that people have about how personal injury attorneys actually get paid under these types of arrangements?
Unfortunately, yes. A lot of people, not a lot of people, but some people think that personal injury attorneys are just money hungry ambulance chasers trying to go out and get as much money as they can and not really support the client's position and get them properly compensated. That's definitely one. And then, there's obviously other people that might be on the other side of the aisle on that one, like the defendants in this case. They're just like, oh, well, I'm always getting sued. I hate personal injury attorneys or whatnot. They're just in this for the money. They want to get my insurance money or, my hard-earned money, things like that. And it's not typically like that. It just really depends on the severity of the negligence or the gross negligence, whatever the case may be. But, unfortunately, like every profession, there is some stigma to, whatever that profession is. There might be physicians, police officers, whatever the case may be. There might be a bad apple. Somebody had a bad experience with them and they just are completely biased towards lawyers and don't like personal injury lawyers in particular because they're money hungry. But, I think most reasonable lawyers will never take more than what the client is getting, because at the end of the day, again, I'm going to show you where all the numbers add up and all the pennies are going. And if my fee happens to be higher than what you're getting at the end of the day after all the deductions, then usually what I do is, because I want the client to be happy and refer me business, is that I reduce my fee so we're at least even, or they're getting more than I am, because they're the ones that suffered the injuries and damages. And some lawyers may do that, others like myself do, and it just depends on the attorney. Like I said, just really got to trust and vet the attorney that you're going with.
Yeah, I was going to finish up with a question about your best advice for someone considering hiring a personal injury lawyer, and vetting seems to be a common thing you've said in this episode.
Absolutely, yeah. Do your reviews on Google. Check out the lawyer in the law firm. Ask around if you have any other colleagues or friends that might have had experience with lawyers. That's very, very important. One thing that I generally recommend is that you typically want a local attorney, like wherever the incident happened. Having local counsel is always a great idea, because that attorney is familiar with the local system. They know how the judges work. They know how the court systems work. They know all the proper local rules and procedures for, specific court or judge. And that's very important, because you want to have a good impression whenever you're inside anybody's court. But other people like myself, like I went to college at UT San Antonio. So San Antonio is like my second home, and I get a lot of cases down there. So I feel like I am certainly qualified to work down in San Antonio as well. But, definitely just vet your attorneys and make sure that they got experience in the particular jurisdiction or venue that you're working in. And another thing is just make sure that, again, you trust them and you feel comfortable with them.
You have a good vibe. You guys could work together, be a team. You mentioned being a team.
Yeah, exactly. Like you obviously wouldn't want some doctor that you don't really know or trust to go and perform some type of surgery on you, right? If we're going to trial, we're going into battle together as a team, and we got to stick together to, get justice for you. And that's always our goal, and make sure that at the end of the day that the client is happy and they've gotten whatever justice they're entitled to.
Absolutely. I like that. All right. Well, thank you for joining us on MF Garza Law Firm, helping injured victims one Texan at a time. If you've been injured and want to learn more about how contingency fee contracts work, visit mfgarzalaw.com. Be sure to subscribe to our channel, leave us a review. We very much appreciate it. Miguel, always great chatting with you. Thanks so much for being here.
Good seeing you, bud. Yeah, it's good talking to you too, man.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.